Good morning, good afternoon, and good evening, friends. Let's continue with the SIC Act and principal employer to pay contribution in the first instance. We have to start from this particular because till last class we discussed about contribution to be made in ESIC portal, right? Now, principal employer to pay contribution in the first instance. So we discussed about who is a principal employer and who is an immediate employer, right? So section 40 subsection 1 provides that the principal employer shall pay in respect of all employer, right? So whether directly or directly employed by him or by through an immediate employer. Suppose there is a subcontractor who has been deployed for providing security services or providing housekeeping services or providing driver services, etc. And the immediate employer being the contractual agency who is providing that service, who is deputing them to the company. So the principal employer has, on behalf of the immediate employer, shall pay the shall deduct and also pay from the wages of the employee, and also the contribution of the employer also has to be paid by the principal employer. Section 40 subsection 4 provides that any sum deducted by the principal employer from wages shall be deemed to have been entrusted to him by the employee for the purpose of paying the contribution, right? So it's assumed, or it is deemed that the employee who is actually working for an immediate employer but has been deputed for the principal employer is assumed to be giving powers for the principal employer to deduct ESI from the wages, right? The principal employer shall bear the expenses of remitting the contributions to the corporation. However, Section 41 provides that a principal employer who has paid contribution in respect of an employee employed through an immediate employer shall be entitled to recover the amount of the contribution so paid from the immediate employer, right? So the principal employer is paying it on behalf of the immediate employer. So the principal employer, as per section 41, can deduct the money so paid on behalf of the immediate employer, and he is entitled to recover the amount of the contribution by deducting any amount payable to him by the principal employer under any contract, or as a debt payable by the immediate employer. So it means that the principal, to summarize it, the principal employer shall pay in respect of all the employers directly employed by him or through an immediate employer, both the employer's contribution and the employee's contribution. Shall pay in respect of, this should be read as employee. So the principal employer shall pay in respect of all employees, whether directly employed by him or through an immediate employer, both the employer's contribution and the employee's contribution. So the sum so deducted can be or will be shall be entitled to recover the amount of the contribution so paid from the immediate employer, either by deducting from the amount due to them or through as a debt payable by the immediate employer. So the immediate employer shall maintain a register of employees employed by or through him and submit the same to the principal employer before the settlement of any amount payable by him, because the principal employer should not incorrectly deduct, right? So should not incorrectly deduct. So there should be a reconciliation between the principal employer and the immediate employer on this sum paid. So for that, the immediate employer has to maintain the register of employees supported to the who has been deputed to the principal employer, and submit the same before the settlement of any amount payable by him. Method of payment of contribution. So section 43 provides that the corporation may make regulations for payment and collection of contributions payable. So such regulations may be like the manner and time in which the contribution has to be made, the payment of contributions by means of adhesive or other stamps affixed on or impressed upon books, cards, or otherwise, or regulating the manner, times, and conditions under which such stamps to be affixed and impressed. Like, see, it's basically the corporation may make regulations like the amount of contribution to be paid in this particular form. It should be affixed, the stamp should be affixed, or it should be in the form of a book, or the evidence of the contribution should be maintained in this manner, etc. So the contribution has to be maintained, and the regulations of payment can be designed by the corporation. So the issue, sale, custody, and production, inspection, and delivery of books or cards, and the replacement of books cards which has been lost, destroyed, and defaced. So the corporation may make regulations on all these matters. Recovery of contributions. This is quite interesting topic. Section 45B provides that any contribution payable under this Act may be recovered as an arrear of land revenue. Suppose a principal employer or an immediate employer who has deducted some money and they have not made payment to the corporation, or they are duty bound to make payment which they have not deducted, or there can be any other legal disputes as well where the contribution has to be paid by under this Act. So if the person who is supposed to make this payment has failed to do so, then the corporation can recover that money as an arrear of land revenue. The authorized officer may issue certificate to recovery officer, who in turn proceed to recover the amount by one or more of the methods mentioned below. What is the methods mentioned? Like attachment of and sale of movable or immovable property of the factory or establishment, or as the case may of the principal or the immediate employer. Like, see, if the factory or establishment failed to make payment as per the regulations, as per the amount due, sum due to the corporation, then the authorized officer may issue a certificate to the recovery officer, who can proceed to recover the amount by sale or attachment of movable or immovable property of the factory or establishment, or as the case may be of the principal or the immediate employer. Arrest the employer and his detention in prison, approving a receiver for the management of the movable or immovable property of the factory or establishment, as the case may be by the employee. So the attachment must the attachment. What will happen if the attachment is insufficient? The total, say, suppose the total number of due amount due is say 1 lakh, and the total value of mobile and immovable property is only 90,000. So so what will happen? The attachment shall first be affected as the properties of the factory or the establishment, and such attachment and sale is insufficient for recovering the whole amount in arrears. The recovery officer may take such procedure as the property of the employer. So the recovery officer can recover the insufficient balance, or the balance amount to be recovered can be recovered from the property of the employer, be it a principal employer or an immediate employer, but the amount can be recovered. Right? Now, let's look into what are the benefits that are available for the insured persons and the dependent. Section 46 deals about it in detail. Actually, it is summarized here, but Section 46 talks about it in detail. And periodical payment to any insured persons, or in case of sickness, right? If there is a periodical payment to be made, then the periodical payment to any insured person in case of a sickness, and periodical payment to an insured woman in case of confinement or miscarriage, or sickness arising out of pregnancy, confinement, premature birth, and birth of child or miscarriage. So periodical payment of any insured person in case of a sickness, and periodical payments of an insured woman in case of confinement or miscarriage or sickness arising out of pregnancy. Periodical payment in insured person suffering from a disablement as a result of an employment injury sustained as an employee. So if there is an employee who is suffering from a disablement, and the disablement is caused because of the out of employment, then the periodical payments to an insured person can be made as a benefit. Periodical payment to such dependents of an insured person who dies as a result of an employment injury sustained as an employee. So it's not only the insured person, but also the dependents who are also eligible for certain benefits under the Act if the insured person dies as a result of an employment injury sustained as an employee. And medical treatment for and attendance of insured persons. Payment. This is quite interesting clause. You have to see it. Payment to the eldest surviving member of the family of an insured person who has died towards the expenditure of the funeral of the deceased insured person, suppose the insured person dies, then payment will be made to the eldest surviving member of the family of the insured person towards the funeral expenses of the insured person. That's more important, towards the funeral expenses of the deceased person. And if the insured person at the time of death does not have a family, the funeral payment will be paid to the person who actually incurs the expenditure. This expenditure has to be claimed within a period of 3 months from the death of the insured person, and or with such extended period as the corporation allow in this behalf. Otherwise, in the normal scenario, this expense should be claimed within a period of 3 months from the death of the insured person. Hope this is clear, right? We'll continue into the other details in the next class, and hopefully we should complete the ESI Act in the next class. So I request you to all go through the ESI Act so far, what we have discussed, and then come back to me for any queries you have on this at babupriya@rediffmail.com. And you can also send an email to me or put a comments against this video, and I'll come back to you soon. Thank you, friends, and have a great and wonderful day.